Honorable Vice President.
Senator Hosein. Thank you very much, Mr. Vice President, for giving me the opportunity to join in this debate, the Evidence Amendment Bill 2019, which is an act to amend the Evidence Act, Chapter 702. And Mr. Vice President, I would just like to begin my contribution with two quotes. And those two quotes come both from the Trinidad Guardian, from two very prominent persons on different sides of the fence when it comes to criminal justice in this country. And the first quote is from the Director of Public Prosecutions, Mr. Roger Gaspard. And on the 1st of July 2016, he was quoted as saying, "The criminal justice system is in a crisis, and we are twiddling virtually on the edge of a precipice." And the second quote is from Senior Counsel Israel Khan on the 10th of April 2016, where he says, "The criminal justice system about to collapse." And Mr. Vice President, in 2016, these two esteemed gentlemen was able to foresee what will be taking place in 2019 in our country, where the criminal justice system in our country has come to a grinding halt, and it is in crisis, and it has failed the people, and the system has collapsed, Mr. Vice President.
Under the PM.
And this was not orchestrated by anyone else but the government, Mr. Vice President. Because for far too long since this administration took the reins of power, there have been several cries from all spheres with respect to the lack of resources that are being given to the DPP's office, to the Trinidad and Tobago Police Service, and the judiciary. The judiciary, I believe, gets less than 1% of the national budget every year, Mr. Vice President. But let us look at what this bill intends to do. Does this bill intend to speed up the criminal justice system? If I'm going to give the bill the benefit of the doubt, I will say yes. Because there are some provisions in the Identification Division 2 of the bill that comes directly from Standing Order 29 of the Trinidad and Tobago Police Service. But Mr. Vice President, there are certain provisions in this bill, or certain clauses, that we as a responsible opposition cannot and will not support, because it intends to infringe upon the rights of citizens, on the rights, the absolute right, as Senator Ramlin would have said, on a right to fair trial for a person who has been accused of a criminal offense. And let us look at the international law on this issue, Mr. Vice President. Article 7 of the Universal Declaration of Human Rights states that all are equal before the law and are entitled without discrimination to equal protection of the law. And that is similarly enshrined in our Constitution. When you look at Section 5, subsection 2F of the Constitution, which Senator Simonet read and said that the bill doesn't interfere with, it says our Constitution protects every person charged with a criminal offense of the right to a fair and public hearing by an independent and impartial tribunal. Mr. Vice President, these constitutional provisions are not just written on pieces of paper, published and placed in law books. This places an obligation on the state, Mr. Vice President, so that the state becomes the trustee of your rights, not the infringer of your rights. The state must respect, the state must protect, and the state must enforce your rights. That is the rule of law. The state must never willfully take away your rights and or infringe them. At the opening of the law term, Mr. Vice President, 2018 law term, the former High Commissioner to Canada, Gerard Latulip, stated, and I quote, Mr. Vice President, "Without rule of law, there is no democracy. If the laws and constitution of a nation cannot be enforced in a fair, honest, and independent manner, the citizens lived under the rule of perverted laws. And Mr. Vice President, we in this parliament do not intend to make any perverted laws, because we want to ensure that while we balance the rights of those who are victims in the court, and we would like, all of us who sit here in this parliament would like to see speedy criminal trials, faster convictions, we must never forget that a person in our country, by our very constitution, is presumed to be innocent until proven otherwise. And the evidence on which a person must be convicted on must be safe, it must be cogent, and it must be compelling, Mr. Vice President. And when you look at a criminal trial in Trinidad and Tobago, because this bill deals with evidence, before a person is convicted by a jury and now by a judge, the state or the prosecution must prove that that person would have committed that offense, beyond a reasonable doubt. And therefore, the evidence that we have to produce and the evidence that the state is allowed to produce must not fall below that muster of beyond a reasonable doubt. It is a very high threshold, because from time immemorial, the rights of an individual who is accused of committing a criminal offense has always been protected. And Mr. Vice President, the Attorney General did speak about deterrence, and he hopes that this bill will act as a deterrent in terms of the manner in which trials are conducted and the speed of it. And I want to agree with the Attorney General also that we would also like that we have laws in this country that will deter persons. But in order for a person to really be deterred, you must have a proper, efficient system in which these laws must be applied in. Mr. Vice President, when you look at the current state of the judiciary, I will go in to give some figures, Mr. Vice President. You would see that clearly the courts are not ready for this, Mr. Vice President. When we look at the last annual report of the judiciary for the law term 2018, Mr. Vice President, if you would allow me to go into the figures, when you look at the number of criminal indictments filed, for the law term 2014, there were 258. For the law term 2015, 192. 2016, 171. 2017, 324. 2018, 46. Mr. Vice President, we have seen a decline in the number of indictments filed. Who files indictments in this country? The Director of Public Prosecutions. We must ask ourselves why. Why is it so? Why do we have a decline? Imagine we went from 258 in 2014 to 46 indictments being filed in 2018. Just imagine that, Mr. Vice President. When we look at the number of criminal indictments disposed of, let us go again. 2014, 167. 2015, 171. 2016, 152. 2017, 138. 2018, 83. Why, Mr. Vice President? Again, a decline in the number of criminal indictments that are being disposed of. Is it that there's a lack of resources at the DPP's office? Is it that the judiciary is being starved for something, Mr. Vice President? All of these laws that we have passed in this parliament, this government comes here and promises us that this will help the criminal justice system. It will speed it up. And this is the evidence. This determines the performance of the laws that you have passed. This, Mr. Vice President, is the performance indicator of the judiciary. And again, when I looked at this report, I was very startled, Mr. Vice President. When you look at the reasons for an adjournment, because they said the attorneys are to be blamed for these lengthy trials, all sorts of other reasons. When you look at what is the highest, the indicator that causes the most amount of adjournments is because there's another trial in progress. And Mr. Vice President, do you want to know why that is so? Because you only have a limited number of judges in the assizes. You only have a limited amount of prosecutors. You only have a limited amount of masters. You only have a limited amount of courtrooms. Obviously, there must be an adjournment because there's no place to conduct trials again, Mr. Vice President. So why don't you as a responsible government, instead of engaging us in passing all of these nice laws, will come and tell us that you built X amount of courtrooms. You ask us for our support to hire judges. Hire more judges, Mr. Vice President. Support for creation of rules. Cat reporting. Mr. Vice President, where are those things? Why do we have to, persons who live in Princestown, do you know, Mr. Vice President, that persons who live in Princestown, who has to access a magistrate court in this country, has to travel to Rio Claro? Persons who go to the magistrate court, are those persons?
Senator, I'm going to allow you some leeway as you're creating the context for your argument as you move towards the bill. You have a few more minutes to do that, so continue. Just know that you're creating that context to then move forward towards the bill.
I'm grateful, please, Mr. Vice President. And yet, Mr. Vice President, I'll just end that point, that in terms of the persons who access a magistrate court, are those persons who are poor in society, those persons who can't even afford to travel. And now you're asking this person that they have to go to Rio Claro to access the Princestown Magistrate Court, Mr. Vice President. And that is the performance of this government. But I will just end on the point in terms of the context that I'm building, Mr. Vice President. This is the last statistic I will quote. Mr. Vice President, as of July 31st, 2018, in the High Court of Justice in Trinidad and Tobago, the Criminal Division, there are 2,006 pending matters, and 696 of those matters are 15 years or plus old, Mr. Vice President. This bill, Mr. Vice President, I respectfully suggest would not ease the backlog in Trinidad and Tobago. This bill will do nothing, Mr. Vice President, because you will have to clear the backlog before you have cases in which were investigated under this amendment to the Evidence Act, which will come next 8, 10, 15 years, Mr. Vice President, because this is the pace of our judiciary currently. And you know who orchestrated this again, Mr. Vice President? I will say it is a PNM government that did that. A PNM government, starved judiciary of funding, trying to restructure the mode in which the judiciary operates. That is why every Monday morning you have workers outside of the courtroom protesting, trying to save their jobs and their tenure, Mr. Vice President. That is an untenable situation in this country. Totally untenable. But let me go on to the bill, Mr. Vice President, because I want to focus on Division 2 of this bill. And Division 2 of this bill, Mr. Vice President, deals with identification. Identification is one of the most critical issues sometimes that face an accused in a trial, Mr. Vice President. And it is also, especially visual identification, is one of the most dangerous grounds in which a conviction should be founded upon, Mr. Vice President. Because when something happens very quickly to a victim, Mr. Vice President, you will find that they are consumed with fear, and they may mistakenly, after the event, still traumatized, not be able to properly identify the person who has committed the offense. And that is why you will have a lot of cases of mistaken identity. And there are very famous cases right in our jurisdiction and other jurisdictions where persons were convicted as a result of mistaken identification by eyewitnesses. Just in, if we look at United Kingdom, in 1970s, there were two high-profile miscarriage of justice cases. That is Laszlo Virag and Luke Clement Doherty, which had relied upon eyewitness identification, which resulted in the establishment of a committee to investigate the issue. And this is a well-known committee that was chaired by Lord Devlin, the Devlin Committee report. And they would have produced several recommendations to combat the conclusive unreliability of eyewitness evidence. And then when you look at the Court of Appeal in England, in the case of Turnbull, 1977, Queen's Bench, at page 224, you will see that that case would have drawn a lot from the Devlin report in terms of the common law now providing some guidance to judges on the treatment of eyewitness identification. And Turnbull guidelines, Mr. Vice President, hinged substantially on the cautions in which a judge should give to the jury with regards to relying on such evidence. Because I said earlier on, it is very difficult evidence. It's not the best evidence. It is sometimes dangerous to found a conviction solely upon identification. So much so that the judge has to warn the jury of certain issues that may follow with respect to reliance on identification evidence. And some of the guidelines that the judge should inform the jury of are that a caution must be given to avoid the risk of injustice. He must also inform them that a witness who is honest may be wrong, even if they are convicted, they are right. A witness who is convincing may still be wrong. More than one witness may be wrong. A witness who recognizes the accused, even when the witness knows the defendant very well, he may be wrong. And there are several cases of that. The judge should direct the jury to examine the circumstances in which the ID by each witness can be made, which would include the length of time the accused was observed by the witness, the distance the witness was from the accused, the state of lighting, whether it was in a dark area or properly lit area, the length of time that elapsed between the original observation and after the subsequent identification to the police. You could also look at obstruction of the view from the victim to the accused, Mr. Vice President. And those are the warnings in which the judge has to give to the jury. And you would see some of those safeguards, Mr. Vice President, were present in the legislation in the United Kingdom, which is PACE, the Police and Criminal Evidence Act. And while we take from the UK's experience, we must also bear in mind that the United Kingdom, their parliamentary system, their parliament is sovereign, whereas in Trinidad and Tobago, our constitution is the supreme law. Our constitution is sovereign, and our parliament must make laws in accordance with the constitution. And it must meet the constitutional muster of Section 13, which we are attempting to do here, in that the laws that we make must be reasonably justified in a society that has proper respect for rights and freedoms of the individual. And Mr. Vice President, if we are modeling our legislation after the PACE, and I will go on to explain during my analysis of Division 2 of the bill, which deals with the identification, is that PACE included a lot of safeguards in the legislation. And when you look at the current legislation, the current bill before us, you would realize that some of those safeguards were actually taken away from what was reproduced right here in Trinidad and Tobago. And one has to wonder why, and we may actually engage the Attorney General in asking, well, why not include these safeguards in the legislation? Because at the end of the day, you have to protect these individuals, and you have to ensure that the evidence is cogent. So let's go, Mr. Vice President, into the bill. And when you look at Clause 12A of the bill, it deals with the first description of the accused. Offense occurs, the victim goes to the police station, makes a report of the incident, he gives a first description of the accused. The first description he has to give will be in an approved form. Now, Mr. Vice President, I looked through the bill, there is no approved form in the bill. One has to wonder why this was not included. This is a special majority bill. I would expect that there must be some level of certainty with respect to this bill, Mr. Vice President, because you are asking a parliament to infringe on the rights of individuals, but yet we are still unsure of what are some of the prescribed forms. We are unsure what the regulations are. The Attorney General said that the regulations have been drafted, sent out to stakeholder. Well, why not include everything together? Why are we coming again? And I always make the complaint, piecemeal approach, Mr. Vice President. Now, when you look again, you see that the first description has to only be kept in an approved form. Now, why doesn't the legislation, and this is a safeguard, impose an obligation on the identification officer or the officer in charge at the time who's taking the report to also make an entry into the station diary? Mr. Vice President, this probably sounds very artificial, But you would understand in the criminal justice system how important a station diary is. Because the station diary keeps contemporaneous records of what occurred. It's very easy in which a form that is not bound can be backdated. The form can be interfered with, Mr. Vice President. But on a station diary, it preserves the time, the date, and the person who made the entries in the station, Mr. Vice President, to avoid any interference or to avoid any corruption with respect to the records that are being kept. It is the most contemporaneous document, and you would realize that the police standing orders also provide that any time any person comes to a police station, a record must be made in the station diary. Now, when you look again, Mr. Vice President, at unless otherwise specified, which is found at subsection B. So it says that the record shall be kept unless otherwise specified, be made before the eyewitness participates in any identification procedure. Then what does that mean? What circumstances does the Attorney General contemplate unless otherwise specified? Because when you go down to clause 12A subsection 3, it says that the investigating officer shall confirm that the first description of the suspect given by the eyewitness has been recorded in the approved form before the eyewitness is shown any photographs for the purpose of identification. So there's a bit of conflict with respect to clause 12A 1 subsection B and 12A subsection 3, Mr. Vice President. Now, subsection C of the bill deals with some of the Turnbull guidelines in terms of the lighting condition, the distances, the weather, how long the person was under observation by the victim. So that subsection C I'm very comfortable with, and it also gives at paragraph V such other particulars that the investigating officer thinks fit. Now that shows that there's a level of discretion in which the officer can use, so it's not very prescriptive, Mr. Vice President. Now I want to go down to clause 12B, and this clause 12B troubled me a lot, Mr. Vice President. Because when you compare clause 12B to PACE, UK Code D at paragraph 3.3, it states that a witness must not be shown photographs, artist composites, likeness or similar likeness or pictures if the identity of the suspect is known to the police and the suspect is available to take part in a video ID, an identity parade, or a group identification. When you look at the police standing order 29 at number 13, you would see it states that the photographs should not be shown to the victim if the accused is at the police station, because it can prejudice any identification procedure to follow. Now, when you look at clause 12B, Mr. Vice President, it seems as though when it's read that even if the accused is in custody, that the photograph can be shown nonetheless. There's no safeguard in terms of not showing the victim the photograph even if the accused is in the custody of the police, Mr. Vice President. And I believe that safeguard should be inserted as prescribed in the police standing order 29, Mr. Vice President, because as I said, it can contaminate the entire identification procedure if the victim is shown photographs of the accused prior to the identification procedure. And when you look at the standing order at section 13, Mr. Vice President, it goes through a list that the photographs of the instances in which a photograph must be used or can be used, to assist in the identification of the suspect. And there's one, and it even states that at paragraph D, the fact that photographs have been used should never be mentioned in evidence in chief, only in answer to cases under cross-examination. And this is because, Mr. Vice President, if a jury hears that the victim would have seen the photograph of the accused prior to being identified, there's something called the rogue gallery effect, Mr. Vice President, whereby the jury can infer that because the police had a photograph of the accused, it means that this person may have been known to the police before. And again, it can prejudice the way in which a jury returns a verdict. Another important safeguard, Mr. Vice President, when we are dealing with photographs is that the photograph shown must bear no marks, no names, no numbers of any kind that may tend to indicate or suggest the identity of any particular photograph. And that is very important, Mr. Vice President. And all of those things are left out. Imagine these things exist in the police standing order, proper safeguards, and then you leave them out from primary legislation. One has to wonder why. Is there some motive behind the expedient passage of this piece of legislation? I hope not, Mr. Vice President. Then, when you look at clause 7, it states that where a person, subsection 7, sorry, where a person has not been positively identified by an eyewitness as a suspect, the Commissioner of Police shall cause all photographs of that person to be destroyed. So, positive identification, destroy the photograph, Mr. Vice President. When you look at PACE, where photographs are destroyed, a notice must be given to the suspect before the photograph is destroyed. An opportunity to attend the destruction must be given, or a certificate issued to the accused to confirm the destruction of that photograph. None of these things exist within the bill, Mr. Vice President. And they're proud, the government is proud to say that we learned from the UK experience. Well, clearly, the learning was not enough, Mr. Vice President. When you look at clause C, Mr. Vice President, in terms of the conduct of identification procedure, it says that an identification procedure not being held where it is not practicable to hold one, but states no specifics. There are different range and different methods in which the identification of the accused can be conducted, and I will go on to that when we reach clause 12E. But, Mr. Vice President, it would be very difficult to contemplate a situation in which they can't conduct the ID parade because they gave so many varieties in terms of video, photographs, ID parades, public place, Mr. Vice President. So when you go down to clause E, 12E, it gives an order of priority. And the order of priority is that the identification must be conducted using a video medium to start with. Then you must go on to identification parade. Then after that, identification in public place with consent of the suspect. Then identification in a public place without the consent of the suspect. And then the last resort is identification by confrontation. Now, Mr. Vice President, the first method that they want us to use is video medium. And the problem with this, Mr. Vice President, it's prescribed, the manner in which it is conducted is prescribed lower down in the legislation. When a victim, when an accused is placed on an ID parade, Mr. Vice President, there's other individuals similarly dressed, has the same color, complexion, height, racial background as the accused. So therefore, when the victim is being placed when the accused is on the parade, the victim will have to positively identify this person amongst persons similarly appearing just like the accused. If a person, Mr. Vice President, I'm going to give a very facetious example. Let's just say we have someone with the complexion of Senator Vieira on the parade. And then you have somebody with a very darker complexion, Mr. Vice President. Obviously, that parade will be very unfair to Senator Vieira if he's the accused. So at that stage, Senator Vieira has the opportunity to say, well, I object to that person being on the parade. I want someone who is my complexion to be placed on the parade. Now, Mr. Vice President, when the video identification procedure is going to be conducted, the accused, neither his representative, neither a justice of the peace, has an opportunity to object to anyone on the parade. There's no provision in which that person can object to anyone on the parade. And that in itself is very unfair, Mr. Vice President. Because when you look at the clauses of the bill and you look at the identification parade, which is done with the victim behind the one mirror glass, a one-way mirror. At that point in time, he is allowed to object to whoever is on his parade before the victim enters the room. Now, when you go and do this video identification, why are you taking away this right of the person to object to those persons who are on his parade? That is, Mr. Vice President, inherently flawed in this piece of legislation. When you look at the judge's rules for children, at Part G of the judge's rules, Mr. Vice President, you will see when the children are placed on video identification parade, they are in fact, Mr. Vice President, given the opportunity to make an objection before the video parade is conducted. Now, when we go on, Mr. Vice President, to the other provisions, it states that everything, again, rights, consents, and caution found at Clause F, everything is going to be done in approved forms. Well, let us see the forms, Mr. Vice President. Or when I looked at the legislation, these forms are made by the Minister in consultation with the Commissioner of Police. Well, I want to take a recommendation from Senator Mark that he does in other pieces of legislation and ensure that any form that deals with a person's rights, their consents, and any caution, Mr. Vice President, be made subject to affirmative resolution of this Parliament. Let us see, Mr. Vice President, what is being done with respect to the implementation of this legislation. Again, let me go on to another provision in the bill where it gives a person an opportunity of 9 hours to present a representative as a representative for a parade. Now, I wonder where the government got this 9 hours from, because when you look at the police standing orders, it gives a period of 12 hours. Why is there a reduction in the amount of time in which a person has to go and seek a representative? A representative can actually be a legal representative, a parent, a guardian. And if you want your lawyer to be present, 9 hours is insufficient, Mr. Vice President. When you look at legal aid, you have lawyers who are no longer taking legal aid briefs simply because legal aid isn't paying them, Mr. Vice President. So all of these are issues in which we have to contemplate before you pass legislation. This is what you call pie in the sky legislation, Mr. Vice President. Now, I looked at Clause 12K of the bill. Clause 12K deals specifically with identification parades. And when you read Clause 12K, at the first glance, you would see that an identification parade shall be conducted in a police station or other building under the control of or regularly used by the police service in the normal conduct of their duties. Here how they conduct in these ID parades, either in a normal room or one equipped with a screen permitting the witness to view the suspect without himself being seen. Now, I have no problem with the second manner in which the parade is going to take place, but in a normal room. A normal room suggests that this room doesn't have the one-way mirror. Now you have, welcome back, Madam President. Madam President, you have a person who has just been raped, Madam President. And then this person now has to come and identify the rapist. Madam President, you are going to put this person in a normal room, standing with this person, and 9 other persons similarly looking like him. Again, you will re-traumatize this victim, Madam President. I cannot agree with identification parades taking place without a one-way mirror, Madam President. I cannot agree with that, especially for victims of sexual offenses. Now, and children. There was also a reduction in the parade number under the police standing orders. For a group of 2 persons, the parade was 14. I see there's now a parade of 12, Madam President. Again, we sought some explanation and clarification from the Attorney General with respect to that. When you look at the police standing orders, Madam President, you would see that there are some provisions in the bill that an identification procedure, and this deals with the identification without identification of public place with the consent of the suspect. At 12M, Madam President, you will see there that that identification procedure can take place without a representative of the accused.
Senator Hosein, you have 5 more minutes.
Thank you very much. Without the accused, the accused representative or a JP being present. If you read clause 12M, when you look at the police standing orders 29, Madam President, you will see it says that on no account shall the suspect be placed on an ID parade without his rep being present or in the absence of a JP. Again, I ask that there must be an insertion with respect to a representative being present where the identification is in a public place with the consent of the suspect. Now, when you look at clause 12N, you would see that there's identification in a public place without the consent of the suspect. Now, I just have one very small note on this, and it says that it runs the risk that an eyewitness may be more inclined to make an ID thinking that the person has to be present as compared to a controlled circumstance, Madam President. Now, these are my comments with regards to the identification of the Division 2 identification of the bill, Madam President. And you can see from the short analysis that I have done, Madam President, you would see that there are certain safeguards that have been left out. You are trampling upon Section 4 and 5 rights, and I believe that as much safeguard shall be placed in order to make this legislation proportional. When you look at the other divisions of the bill that deals with confessions and admissions, which my friends on this side will deal with, and Senator Ramdeen has so eloquently dealt with respect to the witness anonymity, I go back to the saying that where by the High Commissioner to Canada, where he says that where there's no rule of law, there's no democracy, Madam President. And it shows that this government has been engaged in a series of legislation which has sought to trample and erode fundamental rights, freedoms, and privileges of our ordinary citizens in this country. And you have seen that they have continued to starve the essential services of this country, whereby the police service, I am being informed, Madam President, do not have monies to pay for food for the dogs, Madam President. And in conclusion, I would just like to thank the leader of the opposition for the preparation, in assisting us with the preparation of this debate, and the persons also who had assisted us, those practitioners who have taken their time, because they are seriously concerned about the passage of this piece of legislation. We will support good legislation, Madam President, but this piece of legislation we cannot support because we don't believe that it is proportional. We believe that it is unconstitutional. It will not help the justice system as currently as it is. They can pass how many laws, Madam President, it will not ease the backlog unless we start in order to give the essential services the resources. This is an attempt by the government again to engage in a PR exercise, as we have seen the Prime Minister yesterday morning on a very popular morning program, Madam President. Yeah. I know there are several noises being made from the other side, but you will see, as the Attorney General has come to this Parliament several times and promised us that we are going to help, we are going to take out 100,000 cases, family court, children court, criminal division, and none of those things have helped us, Madam President. I am saying that we need more consultation with respect to this bill, and there are others who may say more about that, Madam President, but as it currently stands, we are not in a position to support this piece of legislation, and I thank you very much.
Senator Chote.
Thank you, Madam President, for the opportunity to speak on this proposed legislation. The first observation which I would like to make is that we are asked to enter the debate on the Evidence Amendment Bill of 2019. But having read the substance of the bill, it seems as though we have been asked to debate a criminal procedure bill, because there is very little here which talks about what will make evidence admissible or inadmissible, And there is very little here about what ought to be considered when such legislation may be admitted or not admitted, as the case may be. So I think the substance of what is contained here does not fit well with the rest of the Evidence Act as it stands now. And perhaps this can be cured. I'm not saying that it is something that is incurable. I think that with a little work, there may be provisions which could perhaps be put into parts of this bill which may make it acceptable. There are other parts of the bill, I ought to say, under no circumstances do I find to be acceptable. Having said that, I am pleased to be able to begin with something prepared by a scholar from our TTPS. I have a thesis which had been done by former Deputy Commissioner Maurice Pigott. It was his thesis when he was doing his master's on the law and discourse on eyewitness evidence in Trinidad and Tobago. It is perhaps one of the few documents of its kind. And I think some significance should be given to it simply because this was one of the senior officers who also participated in the preparation of the standing orders which we currently use, prepared by the TTPS. Now, I'm going to refer to 3 pages, just very briefly, 35, 37, and 39. Now, this was data-driven. What the then Deputy Commissioner had done is that he had conducted surveys and he had conducted interviews and done a lot of research with the police, defense attorneys, judges, magistrates, police officers, other stakeholders. And he had analyzed how we view identification evidence. And I start here because the layperson thinks that seeing is believing. Once you say you see, it means that you ought to be believed. But those of us who practice within the system, we appreciate that the reason there are so many rules surrounding this kind of evidence is because it's inherently unreliable. And this is what then DCP Pigott had to say. Empirical research has revealed that eyewitness evidence, with all its vagaries, is still the strongest jury influence in the determination of guilt or innocence. The research has also revealed that eyewitness evidence is the major cause of most wrongful convictions. That position is strongly supported in the precedent-setting cases conducted in Trinidad in 2008. And this is from somebody who ought to know. At page 37, he goes on to explain the composition of modern societies is dynamic as it responds to change for economic and other reasons. Consequently, the issue of cross-race identification in criminal matters is now one of growing importance to police officers here in Trinidad and Tobago. And at page 39, he says, interestingly, all police responses said that eyewitness statements should undergo further investigation to prove the veracity of the information provided. Now, I open with that, and I will connect it with the point I wish to make. In our courts, you can't do what is called ad hoc identification. That generally is disallowed. So there is a great deal of emphasis placed on the identification procedure used, the post-offense identification procedure used, to ensure that the person, the eyewitness, has had everything done to point out or not point out, as the case may be, someone in a controlled environment. Now, when I look at the proposed legislation before us, I immediately have some concerns because, you know, what I find happens too much, Madam President. It gives us, I don't know if it's a colonial hang-up or what, but it gives us a great deal of comfort to say that we are following what the English are doing. I wish in this case we had followed what the English had been doing, because what they did in their Police and Criminal Evidence Act is they had provided for protections for their citizens when that legislation was initially enacted in 1984, when I was still a student. It came with voluminous codes dealing with different aspects of police investigation, identification, confessions, and so on. And these codes have changed and morphed over the years. And one of the authorities at the time, and he still remains the authority, he was the only academic of repute who wrote a text in 1984 on the Police and Criminal Evidence Act, and it was called Michael Zander on Pace. He is now Professor Michael Zander, QC, and I remember him well because I had the misery of having to study that first book. This has now been expanded, and looking at it, you see that the English have continued to amend their legislation to ensure that there continues to be, as far as possible, equality of arms between the parties, and they have tried, within their definition of what is a fair trial, to comply with the controls to ensure that if you have an incursion into the rights of someone, then you ought to have a protection. Now, I think it is important. The point made by Senator Hosein is a very important one. That is to say, we must remember that we operate under constitutional democracy and they operate under parliamentary democracy. And I think jurisprudentially, that's extremely important to the way in which we legislate. And it's not just academic. If you think it's academic, then it means that we just here to pass words and call them law without any kind of thought behind it. Now, when I say that I don't see the protections included in this part that deals with the identification process, I'll just give a few examples. If we look at 12A 2C5, which talks about the record which the officer has to make when he is taking down the first description and so on in the station diary. And the last one says, such are the particulars that the investigating officer thinks fit. Now, the investigating officer may not think it fit to put in his record that the assailants wore bandanas. But I think we can cure that by saying such are the particulars that may be relevant. So that will open it up and that will allow the officer to understand that he has a duty and a responsibility to put in things which are relevant to the identification process. Now, subsection 3, which talks about the investigating officer confirming the first description and so on. I think this must be a mistake because in PACE, when you look at PACE, this whole thing about showing photographs and so on, it is where the identity of the suspect is not known to the police. So you show photographs and you show those photographs in a controlled way to the witness so that the witness may be able to say, okay, well, this possibly may be the person, or the witness may be able to look at some e-fits to see whether this sketch looks like the person who may have been an assailant. So I think that has to be an error because there really is no need for that there. Perhaps if we had done as the English did, we could have cut it up and we could have had different sections dealing with different circumstances in which identification processes are made, and that may have made this bill a little more palatable. Now, I was quite happy to see that what we had in terms of standing orders was now going to be embodied in legislation, because I think that's a good thing. I think when you put rules governing police procedures like these, identification, confessions, and so on, you make police officers understand that they must follow the rules. And if they don't follow the rules, then there will be repercussions. But there is no mention of repercussions in this piece of legislation, and I think this is because the approach to it has been that of setting out procedure as opposed to reasons for admission. Now, when we look at the standing orders, we see that some of the protections that we had there are gone. And I can't understand why, because we are now required, or we are invited to give our support to a piece of legislation which requires a 3/5 majority. What is the reason, for example, for removing the need for the officer conducting the parade to be an inspector or above and confined to that? I know it's later on referred to later on in the legislation, but it seems to have been broadened somewhat to say that if that person can't be found, somebody else can fit in. Well, what's the point of the rule then? Is it that we have so few inspectors or persons above the rank of inspector that we can't have parades conducted? Surely that is not the case, and that has not been the experience of us in this country. Now, this one was a little amusing because there is a section which deals with the order of priority you must look at when you are considering an identification process. Now, we don't have the long time thing of a witness having to walk up to a person on a parade and point him out or touch him and that kind of thing. We've moved on. We have one-way mirrors, and all our identification processes are conducted in that way, except where you have confrontations and so on. The reason the English had the video being made and the video identification process made is because, according to Professor Michael Zander, it is because they were having difficulty getting their parades together quickly enough. So it was easier for them, because they are more technologically advanced than we are, it was easier for them to arrange for a short video to be made with the input of the suspect and have that used with his consent as the identification process instead. So that was part of their law because they had a problem. Now, I don't know that we have a similar problem here. We certainly have not been told so by the Honorable Attorney General in the introduction of this piece of legislation. Or is it a big problem? I don't know. Does it exist? I don't know. And I'm afraid I can't support a piece of legislation when there is not enough information about it. So the video recordings, the protections of the video recordings are not all included in this legislation which we've borrowed. Because under the English system, the accused or the suspect and or his attorney play crucial roles in the selection of the photographs, giving consent to the photographs being used, giving consent to the video which is put together to be used. And even though the suspect is not present when the video is viewed, his attorney at law representative is entitled to be present. None of that is here. And I can't understand why. I don't see why the citizens of this country should have less protection of their rights than in any other place. Now, if I may move on, because this is quite a bit to talk about. Division 3. Division 3 deals with interviews and oral admissions. So, very excitedly, and having read so many cases since 1984 about Section 76 of PACE, I looked to find a similar section in our legislation to say what is a statement and when it would become admissible, because this, after all, is an amendment to the Evidence Act. Well, there's nothing there. What we have is a procedure for the recording of interviews and the recording of oral admissions. Much of this is already set up by common law. And while it's nice to have it in the law, in the legislation, I don't see why we could not have had this section which deals with the requirements for admissibility and the repercussions if you don't satisfy that requirements before you go into the procedure for the taking of statements, whether oral or written. I think that is simply common sense. So all of that is missing. I mean, there is quite a lot of it, nice stuff. You write down the name, the number, rank, and name of the officers present, and so on. And notes should be made in the police station diary of the interview, and so on. Fine. That already exists. But please, if we are being asked to agree to an amendment to the Evidence Act, let us have something more than what we have here. The process with respect to how you video record an interview is absolutely crucial. I have seen it in operation, and indeed done on one occasion by some visiting English officers, and I think it is absolutely crucial, and it will take away from the unreliability of this kind of evidence and the challenges to this kind of evidence, because it will be extremely difficult once you have these video recordings done for an accused person to turn around and say, well, I didn't give it voluntarily, you know, or I was beaten, or I didn't receive my meals, or whatever it is. Because the video recording will confirm, or will be able to confirm, whether such a thing happened. What is the fallout from that? There will be less contests to the admission of these statements, and it may follow on to more guilty pleas where the persons are guilty, and the faster disposition of these matters. Unfortunately, and in fact, the Royal Commission, looking at these, at this aspect of the law, at the time had said that they found such resistance from police officers to videotaping these confession statements. And the reason was obvious, because police officers didn't want people to see what was going on. In addition to that, it made them lazy, because if you could get a confession out of somebody and push it through the court system, then you didn't have to go and look for any other evidence. So I think this part of it is quite valuable. It must be kept in whatever version eventually is brought for consideration by the Senate, because it will have a powerful impact on the criminal justice system. Now, with respect to Division 4, I ought to say that what I considered when I did my reading was the text Criminal Justice, Police Powers, and Human Rights. It was written by Keir Starmer, who is now Keir Starmer, QC, former Director of Public Prosecutions. Oh, Sir Keir Starmer, I beg your pardon, Sir Keir. Michelle Strange and Quincy Whitaker, who I believe is also QC now, with Anthony Jennings, QC, and Tim Owen, QC. So, I thought what was useful about this text was it looked at the English law in the context of the need for these kinds of orders, and it also took us through how these cases were tested before the European courts. Now, it seems as though the idea of having witness anonymity orders came from wanting to protect children in sexual offenses cases, which is, I suppose, in certain circumstances, not a bad thing, but if there are other means of protection, certainly why not employ those? Another consideration was the whole Northern Ireland situation and the terrorist activities which England faced in Northern Ireland. So people were afraid to come and testify, and they had to go underground if they testified and so on, change their names, change the place they lived, change their family names, and this kind of thing. So it is in those extreme circumstances that they legislated for witness anonymity orders. Now, I have not heard one reference to a situation in our beloved republic where there was potentially a miscarriage of justice because we didn't have a witness anonymity order. So what are we doing? What is this legislation intended to provide? What are we curing? What are we helping? What mischief are we addressing? With respect to witnesses testifying by video link, that's fine, it's already happening. And there are controls to that. That's the way to go. It's easier than having witnesses fly in. You can still cross-examine and this kind of thing. And also for vulnerable witnesses, it allows the witness to not be able to see the accused person in the dock, so it takes away from the trauma. So fine, evidence by video link, not a bad idea in certain circumstances. But I absolutely cannot see any justification except for wanting to say that we have it for witness anonymity orders. It is Sir Geoffrey Robertson, QC, when this legislation was passed in the UK, he called it the Perjurer's Charter, because he wrote in The Guardian saying, the Guardian of the United Kingdom, saying that this was the easiest way for someone to go and say anything, and the person who is in the dock doesn't know your name, doesn't know your voice. It means the person cannot even ask for disclosure, because if you don't know who is there, what are you going to ask to be disclosed to you? In fact, it puts the burden on the accused person, in my respectful view, to somehow go and try to dig up information to see if he can fire the right question in the direction of the prosecutor to ask for disclosure. And that goes contrary to the principles of law which we rely on to show that there is a fair trial. One of those principles is that the prosecution, in order to show that, or in order to, at some stage, defend the fact that you've had a fair trial, the prosecution must show that it provided disclosure to the defense so that there could be equality of arms. Now, what you are doing here is you are putting a burden on the accused person to say that I think that this person may be Mr. X, and I think this person may have some grouse against me for whatever the reason, and I think that I ought to be disclosed certain documents or certain material. Now, that is not how the criminal process works. You can't make a request of the prosecution on the basis of, I think. Even in the UK, if you read the reports for 2018, there were horrible miscarriages of justice because of insufficient disclosure. We face that even more grievously here. So we are walking into a situation where there will be clear potential injustice if you are seeking to have someone testify under the shade of a witness anonymity order. Now, Madam President, what I have tried to do is I have not looked at all of the sections, and I've not commented on all of the sections, because if I were to do that, I would only have gone through about 3 or 4 pages. And in any event, much of that can be done at committee stage if we get there. So what I'm respectfully saying is that, in my respectful view, I would like to be able to support this legislation because we waited so long for the PACE requirements. But I think that as it stands, I cannot, because it is incomplete. It's a first run. I think it has to be revamped, protections have to be put in. I think you can't talk about regulations and not have them here for us. When PACE was enacted, they had their codes with all the annexes and whatnot. Why do we deserve less in this parliament, in this country? So when those things are included, and we have a clear idea of what evidence is now going to be admissible and why and what procedures ought to be followed, then certainly I would be in a better position to say whether I can support such an amended version of the proposed legislation. Thank you, Madam President.
Senator Young.
Madam President, I thank you for the opportunity to contribute on this bill entitled An Act to Amend the Evidence Act, Chapter 702. Now, Madam President, today, while sitting in this House and contemplating on my contribution, I sat down and I thought about what was before us. Obviously not from a legal standpoint, because I have no legal training, but just from a layman standpoint. What are we looking at? And what does this mean to the regular man outside? Now, in that contemplation, I happened to take a gander in the gallery and in this August House. And I realized there's somewhat of a prejudice here. And I hope I don't tread on any standing order. But I may be one of the few people here from the East-West corridor. Most people here are from the... No. If we look at the contributions of the people, other people are from different parts, but most from not from the East-West corridor. So I'm claiming the East-West corridor, man. And I understand that I said most. And the reason why I say that is no, I'm waiting. Good. So the reason why I say that, Madam President, is because I live at Barataria. I've lived there all the days of my life. I've gone to Success Laventille Composite, and I'm proud of that fact. Went to school in Mount Hope, lived in Trin City for a while, and back to Barataria. And I know all my life, up and down the corridor, one of the things that always grip, or is always at the forefront, is a matter of crime. And one of the things that you hear on the block and on the street and on the thing is, but if we have video evidence, if we see in a picture of somebody, how come they can't catch the people? Because on your phone, as soon as something takes place in about 10 or 15 minutes, there's a video of that person present on the phone. I can see the person, you can see the person, everybody can identify the person. Now we understand that there is the matter of taking into consideration someone's rights. And I don't intend to tread on anyone's rights. But let me just say this and offer this as a contribution. In 1998, somewhere in the summer of 1998, as Michael Jordan played his last game in the NBA, I was robbed at my house, gunpoint. 3 men entered into my house. They kicked my father, beat him. They robbed us of all that was in our house and left. I don't know for what reason they left me alone, but I saw the gentleman plain as day. Sometime thereafter, I was shown a picture of the gentleman. And I never forgot the officer. The officer's name was Gums from Mover CID. And Officer Gums said, "Do you know this person? Or have you seen this person before?" I said, "That is the man that kicked my father." He said, "Good, we're going to the station." We get to the station and we walk down a dirty stairs and walk into a room that almost looks like a classroom. And as I get in there, he says, "Stand here." And bring them in. Everybody's walking. No glass like I see on the movies. No nothing. Me standing up in front of this man here. And because he would have seen me, and I would have seen him, and he knows that I know him, he's fixed on me for the duration of that time. And I'm telling you, I stood there looking at the gentleman that I know kicked my father. I know robbed me and took my one TV what we had after Michael Jordan when I can't see nothing after that. And I couldn't sum up, at 18 years old, couldn't sum up the gumption to say it was him. Simply because of two fears. One, the man was standing in front of me and seeing me. I saw him in the picture, I identified him. Let me go even further. And this speaks to Clause 12B and Clause 12J. I even have a neighbor who owns a gas station, McIntyre gas station, and he had video evidence. We saw the man. I see the man in the video, there's the man. So I'm here by in Mover Station, I cannot identify the gentleman, and I walked out, I said, "No, I don't see him," and I walked out. In walking out there, my sisters, they were star witnesses and so on forth, but nobody got a better view of this gentleman because they were sitting in a bedroom with poor lighting, and the prosecutor was able to say, well, was it a 100-watt bulb or 40-watt bulb? What kind of bulb it was? Therefore, you couldn't say you see him. But in the front of my yard, we had almost floodlights. I saw the gentleman. In that moment, I was unable to identify him at 18 years old. And what that did is that in the whole summation of the case, although sometime thereafter, some of them passed away and they went to Grenada, and they're all not with us anymore, the 3 men. In that case, I was unable to do my part to my family. And I felt like I'd let them down. That hit me. And when I saw this and I heard this today, I think that this intervention is 20 years too late in my book. But let me go a little bit further. In the contribution of my learned colleagues, especially those of us who are legally endowed, I often hear contribution of the word disappear. And it irks me in some regard, because I am also inclined to the clergy, to hear people speak about souls as disappeared, like if they'd gone into thin air. Because the value of that soul is simply to the case. But let me tell you something. In the submission of Senator Ramdeen, he spoke about a landmark case and a landmark AG that delivered, and I think it was 9 men. 9 men went to the gallows, but 10 men lost their life. Because there was one man who had to give evidence, and he was in police custody, and the minute he left police custody of his own accord, was shot dead. I know this because I was looking at a documentary. And on the point of that one man losing his life, the case almost fell apart. But they used the same language, that the witness disappeared. I mean, almost, but that was a soul. That was somebody. It was somebody's brother and somebody's husband or somebody's something. And if we don't take into consideration these souls, you say, I say I'm from East-West Corridor, I frequent Caledonia and Mova and the Beatum. And though where you all may live, it might be that we have to take care of these people. Where I live, the statement is informed if you're dead. Pardon the patois. So if you are known to be given evidence, Crime Stoppers is work because you can give anonymous evidence. But if you are known to be given evidence and you're too poor to live in some other part, and these days there's not much places you could go, crap or smoke your pipe. So the truth about it is we can sit here in these nice cushy chairs and say, you know, the rights, and I am saying I respect the rights of having each person that is innocent until proven guilty process, but it must be balanced against the rights of those souls that disappeared. Because they did not disappear, they were gunned down and they died, and because they had no value to the lawyer, because they had no value to the case, they disappeared. In terms of, in the fabric of society, they just disappeared to the people who are presenting the civil. But this is what happened, and they just disappeared. So therefore the case, so the life of the case is more important than the life of the person. But let me tell you this. I believe that the government, whoever it may be, and I'm talking about all-encompassing, the parliament, that we are put here by God. We pray every time, we say, God, and according to my scriptures, we bear not the sword in vain. We are to be a terror to those that do evil, and we are to be a light to those who do good. And in that premise, with that paradigm, we take into consideration all rights, not treading on any. But we must remember those who have died. Because the truth is, while Senator Ramdeen claims the success of the AG, he was very successful, and the 9 men went to the gallows. But the one witness also died and didn't get to see these 9 men come to justice. There was another man, another witness that was protected, that's fine. But that 10th man died. And we owe it to him, we owe it to every other witness that from Laventille. Hold on. I am saying to you, Senator Ramdeen, I want to repeat, I live Barataria, Mova. Sorry, Madam President, through you. Not every person was going and killing people. There's some people was fed up and men like yourself spoke on to you to stand up for this nation. And they stand up, and when they were killed, they didn't even get a funeral. This pine box, and they put on the earth because you stand up to decide to speak on behalf of somebody. So I simply say, I appreciate what the EJ is attempting to do on behalf of the laymen. One, to bring evidence that you could, to be able to identify people by picture and video. And where applicable, I think we can also get some benefit in a society to having the anonymity pass as well. And with that contribution, ma'am, I thank you.
Senator. Senator Bisramsingh.
Thank you for recognizing me, Madam President. Firstly, I would like to thank the Leader of the Opposition for giving me this opportunity here today, and I am very grateful for the warm welcome that I have received here today in this honorable House. It is my privilege to contribute to the debate today on this bill, as this bill affects the criminal justice system, and I am here today as a member of the criminal bar. In the past, many bills affecting the criminal justice system have been debated without consultation with the Law Association, the criminal bar, and even the DPP's office. So I am very grateful to have an input here today. I have practiced almost exclusively in the criminal courts of Trinidad and Tobago, and this has given me a working knowledge of the problems that plague our criminal justice system. So I am here today to apply that knowledge. Now, Division 3 of this bill deals with interviews and oral admissions of suspects. In essence, Section 12Q1 of this bill imposes a duty on the investigating officer, who no doubt would be the police officer, to record the interview of the suspect who has been charged. Now, Section 12Q2 goes on to state that this interview shall be recorded by video unless it is not reasonably practicable to do so. Now, the legislation does not state what are the instances of not being reasonably practicable to so do. But of course, we can only imagine it means where the police stations are not equipped with the proper recording instruments, or the recording instrument simply was not working, or even that the police station did not have the proper interview room. So where it is not reasonably practicable to record the interview by video, Section 12Q3 goes on to state that the interview shall be recorded by audio recording if that is reasonably practicable to do. So again, we have the interviewing officer being able to determine whether it is reasonably practicable to interview by audio recording. So although the wording in the bill is shall be recorded by video recording and shall be recorded by audio recording, it does not give the effect of something mandatory or something that must be done. Because by putting in, unless it is not reasonably practicable to so do, it gives the police officer a discretion in recording by either video or by audio. Because in court, all the interviewing officer has to do is basically just come to court with the written interview and say, my lord, my lady, well, it was not reasonably practicable to have it recorded by video or audio, and that's it, the talk done. So this term, reasonably practicable, it gives the police an opportunity to make excuses not to use the video or audio recording. And then what will we have? We are back to square one, because if it is not reasonably practicable to use video or audio recording of the interview shall then be recorded in writing. And that is currently the position as is right now. The interviews are to be recorded in writing. So the entirety of Section 12Q, although in theory it is different to the current position with respect to the interviews, although in writing we have different words, we're bringing in audio, we're bringing in video, the practicality of it, it makes no difference. We are here just wasting ink and paper. For Section 12Q to work in practice, we need to make the video recording mandatory. And we don't do that by adopting the words as proposed here in the bill, by saying that the interviewing officer shall record by video unless it is reasonably practicable to so do. The way this has to be done is to say that the interview shall be recorded by video recording, full stop. No ifs, no buts, no unless. And that is the way we will get video recording mandatory. And why should we make video recording of interviews mandatory as opposed to the audio recording mandatory? Now, there are many instances in court where an accused person would come and say they were threatened by the police officer to say X, Y, and Z. They were intimidated to say X, Y, and Z. Now, wouldn't it be better for us to have a visual of what is going on at the start of the interview and throughout that entire interview? We would not be able to hear if a gun is pointed to the accused while he is given that interview. Similarly, too, sometimes during the interviews, a police officer will ask a suspect to demonstrate an action. Now, it has been my experience in courts that when I am disclosed with interview notes of a suspect, in the written transcripts, it would have, question, when the deceased came up to you, what did you do? And the answer, all they have at the answer is the accused makes a movement with his hand. Reading the transcripts, reading the written record of the interview, I have no idea what is that movement that the accused did. So if it is that these interviews are video recorded, we will be able to see and understand exactly what is going on. Also, too, sometimes during interviews, a suspect is asked to examine a particular object or a particular item. How are we going to see how the accused reacts to what he does when he is examining this object, if it is not video recorded? So all interviews of suspects must be recorded by video recording. And the objective of that is not only for the citizens who are charged with an offense, for there to be accurate recording of what it is that person said, but it is also a safeguard for the police. Because too many times in court, it is alleged that the police beat me, the police threatened me, they forced me to say this, they tell me if I say this, I will get to go home. That is the state of affairs currently. So this video recording of interviews is to safeguard the police officers against any allegations of misconduct. Now, we can't just deal with the theory in isolation from the reality. If we want video recording to be made mandatory of the interviews, we must put the measures in place to have that done. We must train the police officers to carry out proper video recording of interviews. We must ensure that all the police stations throughout Trinidad and Tobago has the necessary equipment to give effect to the video recording. We must ensure that all the police stations has the proper interview rooms to conduct this video recording. And you know what this reminds me of? This reminds me of the Trinidad and Tobago Police Standing Orders. These standing orders are what governs the police officers in the execution of their duties. Now, Standing Order 16 talks about the pocket diaries of police officers and the requirement of the police officer to record everything with respect to an investigation in their pocket diary. Now, when we criminal lawyers in court, we like to ask the police officer who is in the witness box, did you record that particular information in your pocket diary? And you know what is their famous go-to answer? Well, I was never issued with a pocket diary. So where are we going from here? It is a requirement of them to do things a particular way. But if they are not issued, if they are not given the proper support, the proper infrastructure, how can we carry out what it is to be carried out? Likewise, we don't want to make legislation to have video recording mandatory and that there is no follow-through. We need to ensure that the police stations and the police service is well equipped to carry out what it is need to be done, as we are just here spinning top in mud. Further, we need to apply consequences to the police officers for failure to record interviews by video. We let too much things just fall by the wayside. In court, when a police officer does not record an utterance of an accused person in a pocket diary or a station diary, you know what happens? Nothing. It's just, well, do better next time, and that is just it. So what is going to happen when a police officer does not record the interview by video recording? Our criminal courts do not punish improper policing or investigation. The most that the courts will do is just make a comment. So this bill should seek to promote and improve how the police does investigations. This bill should provide for the interview not being admissible into evidence if it is not recorded by video recording unless the suspect consents to it so being. In that way, we're giving effect to what we have in paper. We're giving a consequence. We're giving a ramification for failure to do such. So the police is not just, they're not going to treat this as just a next thing written on paper with no consequences, no follow-through. Now, let us move to section 12T, which deals with an objection by the interviewee to video or audio recording. Well, I have a serious objection to this section. In essence, what this section says is that where an interviewee objects to having the interview recorded by video or audio, the interviewing officer shall record the objection on the recording media, and when the objection has been recorded or the interviewee refuses to have the objection recorded, the interviewing officer should state that he is turning off the recording equipment and turn it off and then continue to make a written record of the interview. So basically, we're saying all of that just to say that once the interviewee objects to having the interview recorded by video or audio, the officer will just revert to a written interview. So then again, what we would have in practice is the police officers coming to court with these written interviews and just telling the court, well, the person objected to having their interview video recorded or audio recorded, so that is why we don't have it recorded. And even further, that the accused person refused to make that objection recorded, so we don't even have the person objecting to it recorded. And we are just made to accept the word of the police officer. This cannot be. Again, the very purpose of having the interviews recorded, either by video or by audio, is to safeguard the police officers against allegations of misconduct. So how are we safeguarding them from accused persons saying that they were beaten and they were threatened into saying what they did if these interviews are not recorded? A camera should never be turned off. Why are you letting the suspect dictate how the police should work? You should not give the suspect an option of having the interview video recorded, because this is to protect them as well. Now, I could understand where you would want to reach a middle position, or you would want to give an accused person options when it is something that infringes on their rights or privileges. But having an interview recorded by video is to their benefit. It helps them. So it makes zero sense to have Section 12T included in this bill. It adds nothing to the current position with respect to having a written record of interviews. This section should be struck out entirely. With respect to Section 12W, which deals with the breaking of the seal of the master copy of the recording, I propose just a few amendments. At subsection 6 of this bill, it is stated that where the seal of the master copy is broken and a copy made of the master copy, which is then resealed, the officer has to record the procedure in the approved form. Now, this should be amended to include that this procedure should be recorded in the station diary of the relevant police station. Now, the importance of this lies with the fact that a station diary is a permanent record at the station which cannot easily be tampered with. once you record something there, it's very hard to go and backdate it, to erase it, to add something to it. So this safeguard of having it recorded in the station diary should be included as well. Additionally, subsection 7 goes on to say that where the interviewee or his representative is not present when the seal is broken, it shall be broken in the presence of a justice of the peace, who shall then reseal the master copy. Now, what I suggest here is as an additional safeguard for the police officers, arrangements should be made to have this procedure visually recorded. And this safeguard is contained in PACE at 3.28 of Code E, which speaks about the same manner, the same process of breaking the seal and resealing it. Now, when we go on to look at 12X of the bill, which speaks of oral admissions of a suspect, it requires the investigating officer to make a note in his pocket diary and the station diary of any oral utterance. It further states that the note will be read to the person, who will then be asked to sign it, and if he refuses to sign it, a written record will be made of that. Now, all of that is nothing really new to the current practice with respect to oral utterances. And with respect to oral utterances, we take guidance from the case of Frankie Bertram versus the State, Criminal Appeal number 17 of 2003, where the Court of Appeal gave guidelines to the police officers when dealing with an oral confession of an accused person. And essentially, the guideline which was given there is basically the same thing here, that a note must be made in the pocket diary and the station diary, and the accused person shall be asked to sign it. Now, these guidelines were given because oral confessions, by their very nature, are very easy to fabricate and very hard to disprove. An example of this is the Central Park 5 case. In 1989, a jogger in Central Park was assaulted and raped, and others were assaulted, robbed, and attacked as well. 5 juvenile boys, 4 being African American and 1 Hispanic, were tried for these offenses, and they were arrested, charged, and tried based solely on confessions, which these boys said were coerced and false. Before the trial, the DNA which was found was tested, but it did not match any of the 5 boys. Nevertheless, they were all convicted by juries in separate trials, and they spent between 6 to 13 years in prison. In 2002, a serial rapist and convicted murderer, while he was in prison, confessed for those crimes, and the DNA evidence confirmed his guilt. So those 5 boys were wrongly convicted based solely on an alleged oral confession. This bill here, it does not provide anything more than what is the current position in practice with respect to oral admissions. Almost every day in court, we are faced with situations where police officers are relying on an oral confession of an accused to establish their guilt. And this utterance that they are relying on, it is usually never recorded in a pocket diary. And in the instances where they are recorded in the station diary, they are hardly ever signed by the suspect. And what happens when these requirements are not done or followed by the police officer? Nothing. So it cannot be that this bill is just restating or making law of what the current practice is here. This bill needs to do better. This bill needs to go further and give a consequence for non-compliance of the section. It does not make sense. We are here drafting and debating this bill, and nobody is complying with it because there are no ramifications, no consequences for non-compliance. So what this bill needs is a section that says that the failure to record the oral admission in the pocket diary and station diary, together with the failure of inviting an accused person to sign it, will result in the oral admission being non-admissible in court unless with the consent of the accused. And by doing this, we are ensuring that the police officers are doing their jobs properly. And it is very necessary for this part, the oral confessions part. Now, Section 12Y goes on to talk about a video or audio recording of the whole or part of a witness statement shall be admissible as evidence. So this section envisages that the recording is done at the police station. Now, this recording would be admitted as evidence rather than a statement of the police. Now, at the police station, there are no safeguards. This audio or the visual recording can be done instead of oral testimony, but direct oral testimony is the best type of testimony in a court, because at the police station, if you have the video audio recording, there is no oath being administered to the person. We don't see the surrounding, we don't see the atmosphere, we don't see what is going on at the background. The formalities at a police station are not the same that exist in a court. So Section 12Y should be amended. Anything else? Okay. Madam President, as a criminal practitioner, I would support any bill that improves the criminal justice system. And I submit that this bill does not do that. Thank you.
Honourable Senators, permit me to congratulate Senator Bisramsingh on her maiden contribution. May I also crave your indulgence? It was remiss of me to not congratulate Senator Young on his maiden contribution. Senator Heath.
Madam President, thank you for the opportunity to contribute to this bill entitled An Act to Amend the Evidence Act, Chapter 702. First, let me start by saying that I find it commendable, having read certainly the earlier parts of the bill, that the bill seeks to incorporate into substantive legislation that which exists already in the common law, our local case law, and that which exists in the police standing orders. That, to me, is of no small importance, because for far too long, from my own experience, police officers have been extended certain amounts of latitude by simply not knowing their standing orders. I think where it is in primary legislation, their failings will become more apparent when they do not know the law. So, for that reason, where there's an attempt to incorporate into the bill these pieces of common law, local case law, and the standing orders, that is to be encouraged. There, however, what we need to be cognizant of is that when there's an attempt to incorporate, for instance, the existing standing orders, and learned senior counsel, Senator Chote, would have alluded to it, it would be important that we do not take away from the existing safeguards that already exist. Because what would then happen is there would be a conflict between the substantive legislation and the standing orders, and it will be to the detriment of accused persons. It can be no intention for that to take place.
I will show in a short while how the bill does not replicate all the safeguards. I certainly would not go over it. I will just show a few examples. But that is something that certainly needs to be looked at, and the bill in that regard needs to be tweaked. Just to give the example, the first example, if we go to 12B of the bill, it says, prior to the conduct of an identification procedure, an investigating officer may use photographs to assist in establishing the identity of a suspect. And if a police officer were to read that, he would take it literally and go to the photographs before going to the identification procedure. But when you go to the standing orders, particularly Standing Order 29, it says a lot more. It says photographs are not to be used if a suspect is in custody and it's the intention to place him on a parade. And there's no circumstances are photographs to be used without a follow-up procedure, a follow-up identification procedure. It would be important, therefore, to replicate what is in the standing order into the proposed bill. On that same point of photographs, Standing Order 29 goes on to say, where there are two or more witnesses who may be able to identify the suspect, one witness at a time should be shown the photograph. If one of them identifies the suspect, the photos should not be shown to the other witness. And it goes on to say a lot of other things which are simply absent from the proposed bill. I see there in the bill, there's also, they seek to put in what is known as the turnbull directions. I also find that commendable. Madam President, I am at 12A1, 12A2C, and it refers to what we commonly refer to as turnbull directions when a case rests solely or substantially in any way on identification. I would make two suggestions. Firstly, I would include as a factor that the witness state whether or not anything obstructed his or her view, and also with respect to Roman numeral 4, where it states the time during which the eyewitness was able to observe the suspect, I would change that to the length of time the eyewitness was able to, or to the duration, meaning the length of time, not the time, if it may be ambiguous. I observe the bill seeks to prioritize the mode of identification procedure to be adopted. And while I have no difficulty with such a prioritization, it should not be that the identification parade is relegated. In the standing orders, the identification parade is the first port of call, and I think it should remain that way. If an identification parade is carried out in a manner in which it is envisioned, it remains the safest method against an accused being wrongly picked out. What has happened, in my experience, is that by the time we get to court, or by the time I'm retained, and I inquire of my client, did you have an identification parade conducted? I'm told no. They just brought the witness into a room with me, and they said I was the person. I understand that to be a confrontation. Now, the confrontation is usually the last port of call. But what has happened is, because there are some practical challenges with an identification parade, Madam President. It's my personal view that police officers are just going to the easiest method, which is the confrontation, and therefore bypassing the safeguards which come with an identification parade. And so in cross-examination of these police officers, who are usually inspectors, they cannot say what efforts they made, they cannot say where the efforts were recorded with respect to trying to assemble an identification parade, which leads me to believe that these efforts were never made, and they simply went to confrontation. So when I see in the bill there's the use of a video medium, and the Honorable Attorney General says there has been some input from the TTPS, I suppose they would have suggested a relegation of the identification parade to suit their own designs. But we must address our practical difficulties, and the identification parade is simply this. To get persons to form an identification parade, you have to give them an incentive. And we have long gone past the stage where a flask of rum from the police canteen will do. It will only attract a certain type of person who has a proclivity for a drink. So it's either we revise the incentives for persons to come and find it useful for their time to form a parade because it is important. So we must not undermine the importance of the identification parade, and we must not relegate it in the priority. It should remain on top. I see at 12G1, they say that a reasonable opportunity to have a representative present, and they've put that at 9 hours. I find that equally commendable. But that must also be with the concomitant right for an accused person to contact their representative. Because if you have a right, but you do not have the opportunity to access the means of that right, well, that is an empty right. So that is something that should also be placed in there, even though we know that there's a right to a phone call. But that right to that first phone call might be to tell someone that you are at a station, and not necessarily to tell someone you want them to be a representative. And I think that is something that ought to be inserted. With respect to the video medium as an alternative, I find it should come lower down, but I also see that there's no provision for representation of the accused person who is not present. I know Senator Hussain would have alluded to that as well. That should also be placed in there with respect to representation of the accused person. I personally find it commendable that with respect to interviews and oral admissions, that police officers will now have it as a force of law. The thought of that is a welcome addition to the law, because again, what has happened far too often is that police officers who have ignored their standing orders and who do not protect themselves in the way envisioned by the pocket diary, which is their #1 safeguard against fabrication and concoction, to put a contemporaneous note as to the event that has taken place with any accused person, including any utterance which is attributed to an accused person. Perhaps if it is force of law, we will see use of these diaries more frequently, and these notes being made in the station diary as well as the pocket diary, and accused persons being asked to sign. Madam President, with respect to the mode of recording an interview, I want to say that the use of the video recording is best practice. It should be encouraged. It helps the justice system in ways in which all the stakeholders can be happy, because when the video recording, which is admissible and produced as evidence, so that an accused person cannot make an allegation, or an allegation which is likely to be believed in any way, that the police officers coerced him or beat him, he would look to see the best deal he could get by pleading guilty and getting that third discount. It helps the justice system because these matters get in and out of the court a lot faster. The evidence which the police are able to produce is more cogent, and so that to test the waters by going to a trial is less desirable. If we encourage this best practice, I think we would go a long way in seeing matters come through the system a lot faster. And so that is to be encouraged in a real way. With respect to 12 Y. And I'm here, but 12Y, subsection 2. A video or audio recording may be made of the examination in chief, cross-examination, or re-examination of a witness, and the whole or part of such recording shall be admissible as evidence of the testimony of that witness. Madam President, I confess not to understand in what context this particular provision exists. It seemed to me to suggest that, like in the United States, where deposition evidence can be taken at different chambers of attorneys, it would make sense there. But in the context of how it appears in the bill, I cannot envision where examination in chief, cross-examination, and re-examination can take place anywhere but in a court of law. So that I do not understand that, and it follows the following provisions following from that equally. The Honorable AG will have to explain that, because I do not understand the context in which it fits into the bill. Madam President, I'm certainly trying not to go over territory which has been covered. So I'm skipping those parts which I know have been addressed. But let me come straight to what is Division 4. Special measures, evidence by video link, and witness anonymity orders. Now, I certainly understand the thrust of what is being proposed by the bill. I certainly can perhaps envision circumstances where these anonymity orders may be useful. But in any event, these must be the exception rather than the norm. I see, with respect to vulnerable witnesses, may include any trauma suffered by a witness, in the criminal justice system, persons who are victims of crime can fit easily into that. I see the witness being a virtual complainant in proceedings for a sexual offense. The idea is that this cannot be the normal procedure, because the very fact that a witness is anonymous tramples on the fair trial rights of the accused. It speaks to a sort of forbidden reasoning that your accuser in a criminal process would never be known to you. This bill proposes to dispel the forbidden reasoning. Now, Madam President, let me say, over the course, within the last 10 years, there has been significant gains made by way of bills which have been passed, which have, for want of a better, which have benefited the prosecution of matters. So where in the past hearsay statements could not get in, we are met with an avalanche. When I say we, the practitioners at the criminal bar, we are met with an avalanche of applications to adduce hearsay statements because witnesses are fearful, and we have to fend them off each and every time. So it is not that, and these are witnesses, mind you, that they don't turn up. Their statements go in as evidence in chief, and it's not subjected to cross-examination. We have endured the introduction of the bad character evidence, which again touched on the forbidden reason that because a man has been convicted for a particular crime does not mean that he did this one, which is what the bad character applications now seek to do and have done. So this one would be another in a series of legislations which do not in any way benefit an accused person. But simply because it does not benefit the accused person does not itself mean that it is not good for society as a whole. But having said that, we must take into context, and certainly from my lens, the society that we live in. I have always stated that there is a certain lack of maturity with respect to criminal litigation between the prosecution and the defense. There is a certain level of mistrust. And when you add to the mix the police service, there's an equal level of mistrust among us. It's against that backdrop that we need to be very careful if it is we want to be introducing anonymity orders. Special measures such as video link for witnesses who may be fearful, I find least objectionable. I have a particular difficulty with the screen in a court setting when the only person who cannot see the witness is the accused person. That might operate in a prejudicial way towards that accused person. And that's why I would prefer, if faced with the choice, to have the person give evidence by way of video link. It must be, in any legislation, a last resort, an anonymity order from a court. But independent of that, respectfully, the bill, in my view, lacks certain safeguards, which I'll ask the Honorable Attorney General to consider. So just by way of example, if I may just state a few. There's no provision for hearing an objection by an accused person through his representative. It is the court to consider and then make the appropriate order. The justice system works best when the stakeholders work together. So if a judge has to make a determination on an anonymity order, that judge is best served with the assistance of the prosecution and defense counsel making submissions if they so wish to do. The bill does not seek to address if the accused person wishes to make an objection that he has a right of audience. I had looked at the parallel legislation in Scotland, which is the Criminal Justice and Licensing Act, Scotland 2010. And that provision with relation to an accused person being given the opportunity says that the court must give every party to the proceedings the opportunity to be heard on an application under this section. Section 271U speaks to the discharge and variation of the order so that in the event that an order is made and new information comes to light, either party can make an application to either discharge or vary the order. And if I may read what that section says, this is 271U. This section applies where a court has made a witness anonymity order in relation to any criminal proceedings. The court may discharge or vary or further vary the order if it appears to the court to be appropriate to do so in the view of the provisions of section 271R and 271S that apply to the making of the order. The court may do so, A, on application made by a party to the proceedings if there has been a material change of circumstance since the relevant time, or B, on its own initiative. Subsection 4 says, the court must give every party to the proceedings the opportunity to be heard, A, before determining an application made to it under subsection 3A, and B, before discharging or varying the order on its own initiative. Staying with the relevant legislation in Scotland, there is also a right of appeal. And this is an appeal with respect to the order. Because there is no provision in any legislation for a procedural appeal in the criminal court, essentially what you'll have to do is to wait, the order is made, you go to trial, and if you're found guilty, you take it as a point at the Court of Appeal when it comes up how many years after that. There is, however, a right of appeal, and I would ask that this be considered. Such is the gravity of these orders. And in Scotland, at section 271V, it says this: the prosecutor or the accused may appeal to the High Court against A, the making of a witness anonymity order under section 271N, and it goes on to address if the order is not made, there may also be an appeal. I think that the insertion of a right of appeal of such an order will seek to temper or allay certain fears that persons may have about these orders being made in the first place. So that if you have this opportunity to appeal, it may go a long way in seeing the bill through its various stages. I know the Honorable Attorney General had referred to the Davis case. I just want to give a citation from Fortas J. in U.S. Supreme Court in Smith versus Illinois, cited in the Davis case. And it really is just to show when you take away the major tool in a criminal trial, which is cross-examination, which is what would happen if an attorney simply does not know who is given the evidence, the effect that it would have on the trial. And this is what he had to say. When the credibility of a witness is an issue, the very starting point in exposing falsehood and bringing out the truth through cross-examination must necessarily be to ask the witness who he is and where he lives. The witness' name and address opens countless avenues of in-court examination and out-of-court investigation. To forbid this most rudimentary inquiry at the threshold is effectively to emasculate the right of cross-examination itself. And that is just the fact of who you are and where you live. There is a lot more with respect to an anonymity order. There are simple things that not even the prosecution would know. They would not know, for instance, the reprehensible conduct of the person, this particular witness, beyond whether or not he has convictions, which the prosecution can disclose. They would not know what motive lies beneath this witness, or they may not know the malice he has with respect to an accused person. That is information that an accused person may have. Madam President, suffice it to say, a lot is being asked with respect to the bill. A lot is commendable in the bill in what it seeks to introduce it as force of law. I think I am of the view that a lot of what is troubling to me, it can be cured, but there are certain things has to be done first. I thank you.
Senator Thomas.
Madam President, I rise in support of the Evidence Amendment Bill 2019, which seeks to amend the Evidence Act, Chapter 702, to provide for the use of different identification procedures, interviews, oral submissions, special measures, the taking of evidence by video link, and witness anonymity orders. Madam President, my friend and colleague on the independent branch, Mr. Heath, has said a lot, 90% of which I agree with, some of which I would have said here tonight, but I would not bother to bore them because they will be hearing the same repetition. But Madam President, the concepts of all are equal before the law and the right to a fair trial and the question of the state infringing on the rights of persons are all concepts that are common and regular in the discourse of law and among practitioners in the criminal justice system and in the civil procedures system. As they are also common among the normal everyday citizen who has an educational background, and care about their livelihood in Trinidad and Tobago. The common man in the streets who lives a decent life is more concerned about the number of prosecutions that are secured by the state in the criminal jurisdiction. Lady, as a practitioner myself, I am happy to see in this bill innovations that will allow the criminal justice system to function in a more efficient way and to produce what most of us yearn for, a fair trial among both parties who find themselves before the court. My experience in the criminal practice system has not always been nice. And I recall one night around 10 o'clock, someone called my phone and asked me if I can present myself at a particular police station in Trinidad. And when I got there, I spoke to a client, and he told me what his problems were. On leaving, I went to the corporal, and I indicated to him, I said, when you all are having your identification parade, I would like to be present. Is there a set time when you have it? He said 3 o'clock. Tomorrow they will be having the parade. So I find myself at the station, spoke with my client again, then spoke to the inspector, and he said, we're having difficulties in putting the parade together so that we're not sure, but we should have it by 6 o'clock. So I indicated to him, you can have my number, and once the parade is to take place, you can give me a call, and I will find myself here within the space of 10 minutes. I received no call, so I went back at 10 o'clock the night. When I got there, the corporal at the cemetery desk indicated to me that the parade went at 7 o'clock. Madam President, if for no reason whatsoever, but for that reason, I will support 100% the question of videotaping of these proceedings. There are many occasions that you go to the court, and these identifications are supposed to be done on forms and written. When you ask for disclosure, sometimes you get 4. The parade is supposed to be 9 persons, you get 3. They'll bring the rest for you, and you start the matter without having seen any. Lady, if videotaping will bring some degree of surety and certainty to the justice system, I will support that and support the government in its quest for any such thing. And it is not only there. It is not only there, man. Madam President, I share similar concerns with every attorney and every member of this Senate who believe that their Section 4 and 5 rights under the Constitution will be affected by the fact of what is contained in this bill and the whole question of anonymity orders and so on. I have engaged myself into practice in this jurisdiction, particularly in sexual offenses matter, that really and truly involves young people. And when I say young people, children. And it irks me sometimes when I see children in a box giving evidence. it is one of the most stressful things for any child. In the witness box. I have been involved in trial, and by and large, Madam President, all that we are harping about here, it is practice in practice. These things are practice in practice. I have been involved in trial where we actually hide the defense or the defendant or the accused so that we can allow children to give evidence without having to go through the trauma of watching the accused face. And we are asked by judicial officers to, let's agree that they don't show them these people because they will not be able to give the evidence and so on. I mean, lady, really, Madam President, if for some reason we as leaders in this society is concerned about making just laws, laws that are reasonable, justified, what else will justify not having into law these elements of this Evidence Act, if not to protect our young ones? A fair trial, Madam President, doesn't go one way. A defense attorney may say that he has his defendant to protect, but the accused also have the dignity and the pride to protect. And they have all right to do so in confidence that they know what is in the legislation so that they could at least afford themselves some degree of comfort to know that they are reasonably represented by the law. I mean, lady, Madam President, I haven't gone through all the facets of this document because of time and the time it came to me. But I want to say that the government, in its quest to ensure that fairness exists at every level of this society, is trying its very best to ensure that legislation that comes to this House is representative of the entire society. And I ask honorable members of this House, and I agree with some of us that there are some concerns in the Act, but I also agree that the Act presents itself with more advantages than disadvantages, and we should find some way in our hearts and minds to ensure that this piece of legislation becomes law. With these few words, Madam President, I take my seat. Thank you.
Acting Leader of Government Business.
Madam President, I crave your indulgence to revert to a matter on the order paper which was deferred earlier. It's under item number 9, and it's question number 188, which is due for written response today. Madam President, I ask for a deferral for 2 weeks.
Question number 188 is deferred for 2 weeks.
Madam President, in accordance with Standing Order 14.5, I beg to move that this Senate be adjourned to Tuesday, April 9th at 10 a.m. And on that day, Madam President, we would consider the Non-Profit Organizations Bill 2019. Thank you. Yeah.
Honourable Senators, before I put the question on the adjournment, leave has been granted for 2 matters to be raised. Senator Mark.
Thank you very much.
Thank you very much, Madam President. Madam President, a meeting it was called a special meeting of the CARICOM heads of government took place in Trinidad and Tobago sometime during the period December the 3rd to the 4th, 2018. And at the end of that meeting, a declaration called the St. Anne's Declaration was issued. There were a number of commitments identified and issued by the heads of government. And Madam President, whilst we are all committed to the Caribbean single market and economy as the alternative government, we find it strange that the government of Trinidad and Tobago, headed by the Prime Minister, could have appended his signature to declarations and commitments without any consultation with the population of this nation. I wouldn't want to bore you with all the commitments that the government, led by the Honorable Dr. Heath, Christopher Rowley, who is campaigning right now in Diego Martin West.
Nothing wrong with that.
I have no problem with that. If you have to call a snap election, let me know. Yes. In September. Right? So, Madam President, whilst he's campaigning in Diego Martin West, we have a situation, Madam President, where the government has committed itself to a number of matters. For example, Madam President, the Jamaican people established a team led by the former Prime Minister, Bruce Golding, and they prepared a document, a book, on the way forward. And they gave CARICOM a 5-year period to put its act together, or else Jamaica gone. Them gone. But at least Jamaica went to the Parliament with their position, and both the opposition and the government agreed. They agreed. There is a consensus in Jamaica on the Bruce Golding report. So what has happened, Madam President, is this. This report out of Jamaica gave us and CARICOM 5 years to put its house in order, to get CSME together. Our government signed a document saying that we are going to implement CSME and all its commitments within 3 years. So in this declaration, which was signed by the Prime Minister on behalf of Trinidad and Tobago, we have agreed to the full, and I want to quote, we agreed that those member states so willing would move towards a full free movement within the next 3 years. And the government of Trinidad and Tobago signed off in agreement. Madam President, they also agreed, among other things, without our involvement and participation and agreement as a nation, that they will now include a new category of workers for free movement, agricultural workers, beauty service practitioners, that is, beauticians, barbers, and security guards. And that would be added, Madam President, to the category called skilled nationals. So you are going out there signing away Trinidad and Tobago, where we have a lot of challenges here, to allow people like agricultural workers, security workers, barbers, and beauticians to come into Trinidad and Tobago and work freely. Not only that, Madam President. No, we support in CARICOM, but you must get the agreement of the people in order to implement that. You cannot do that just so. You may say so. You may say so. But, Madam President, they go further. They go further, Madam President. So you are bringing people into the country. They will have the right, Madam President, to access education, access our healthcare services. I have no problem with that, because we said we are committed to the CSME. But there's no consultation. In addition to that, Madam President, this government, led by Dr. Heath, Christopher Rowley, who is campaigning in Diego Martin West for the next general election in September. Sorry, Madam President. Yeah. Yeah. So, Madam President, you know what they agreed to, Madam President, too? Also, they also agreed, Madam President, to what is called contingent protocol rights. Yeah, what the Prime Minister said in a statement, and I have it in front of me. Commitments given. Free movement of persons. In the declaration, this is what we committed to. Move towards a free movement within the next 3 years by 2021. Madam President, once ratified, the government will come to this Parliament and comprehensively review the relevant legislative and administrative frameworks governing entry and stay of CARICOM nationals. They go on further, Madam President, to say this is another commitment with regard to the free movement of skilled community nationals. As I said, it includes the categories I mentioned earlier, agricultural workers and so on. They also agreed to reiterate that a skills certificate issued by one member state would be recognized by all member states. So you sign one in Trinidad, you can go to all 15 countries. You sign one in Jamaica, you can go to all 15 countries. That is what they have agreed to. And then they have to also deal with the...
Senator Mark, you have 1 more minute.
Yeah. So, Madam President, we are calling on the government to indicate to this country when are they going to consult with the people on these matters before bringing legislation to this Parliament for approval for these initiatives and commitments. Because, Madam President, we need to have consultation. Or is the government signing off, Madam President, these matters, and then they're hoping to win the elections, or they want us to implement these measures? So, Madam President, we want to get a clear undertaking from the government today. When are we going to have consultations on these matters in the interests of our country?
Minister of Foreign and CARICOM Affairs.
Madam President, Trinidad and Tobago has been in the vanguard in bringing to the fore within CARICOM a renewed focus on CARICOM single market and economy matters, CSME. The Prime Minister of Trinidad and Tobago, at a special heads of government meeting which was held in Trinidad and Tobago towards the end of last year, the beginning of December 2018, treated with this important issue of the CSME. Our national self-interest, given the significant levels of exports by Trinidad and Tobago manufacturers to the CARICOM market, as well as our vested interest in a successful integration movement, compels us here in Trinidad and Tobago to participate within CARICOM in a responsible manner. Heads of government agreed to an increase in the number of categories of persons from CARICOM countries eligible to move and work in other member states of CARICOM. Efforts are currently being directed here in Trinidad and Tobago to ensure that good faith prevails and our commitment to increase the number of categories can be realized. We are committed to ensure that the increased standing and leverage of our country, Trinidad and Tobago, as part of a successful CARICOM can be attained. Thank you very much.
Senator Mark.
Madam President, may I raise another matter of interest to the population?
Raise the same one. He didn't answer.
Well, he never answer anything.
No, Senator Mark.
Sorry. Withdraw what?
Of course.
Anyway, let me just, Madam President. Madam President, let me indicate on this issue a very important matter of great concerns to the population. We were told, Madam President, by the distinguished Minister of Finance some time ago that the government is about to take a decision to sell out the CLICO portfolio, insurance, I should say the insurance portfolio of CLICO. And we were told, Madam President, that there were several bids or bidders for this insurance portfolio. Two of them were successful. Sagico Financial Corporation and Maritime Company Services or Insurance Company Services Limited. The minister who purportedly is looking after the public's interests triggered Section 44F, subsection 5 of the Central Bank Act in order to ensure that the interest of the population is not jeopardized. What was alarming and disturbing is when the minister informed the population that the preferred bidder, which is Sagico Financial Corporation, bid $300 million lower than the other competitor or bidder, that is Maritime Services or Insurance Company Limited. And the question here, Madam President, is this. Sagico, we understand, was supposed to be purchased by a Canadian group called Alinvest for $536 million US. That is now on hold. Sagico is registered in Barbados. Sagico is incorporated in Bermuda. So the question that has to be asked is, the minister is now making a case, and this is what I saw in a newspaper report on March 30th, 2019, Saturday Express, in which the minister is alleging in this article and given the impression from what I'm reading that the central bank has already taken a decision to sell the CLICO insurance portfolio to Sagico. But the minister purportedly is supposed to be representing our interests and is yet to take a decision because a foreign investor license has to be issued for them to gain control of our insurance industry. The minister must take into account, Madam President, that if you sell CLICO portfolio to Sagicor, Sagicor will now have a concentration of ownership and a very influential part of the insurance industry in Trinidad and Tobago. And I get the impression from when I read this article, the minister is making a case for Sagicor. Because in this article, the minister, and I quote, the minister is saying that the company that made the lower bid is a strong, substantial company, and the risk of that company failing is low in the future. But the minister is also telling the country, Madam President, that this same Sagicor bid $300 million lower than the Maritime Financial Group. And the question that has to be asked in the public interest, Madam President, who is really looking after the interests of the people of this country? Because you have a Minister of Finance butting, literally defending one bidder that has already been given the green light by the Central Bank of Trinidad and Tobago, according to what I have read in this article. That is what I have read. And the minister must tell us this evening what is the role of the Minister of Finance in defending the public's interest in this matter. Because I saw in this, I have done a research here, Madam President, on the shareholders of Sagicor. And I'm seeing the young people having a big directorship there. Richard P. Young is a director. He's a director. So I am wondering, Madam President, and the minister must explain, because Angus Young is in NCB, and we have a minister in the government. So we want to know, Madam President, whether who is looking. That is what I'm trying to do. I am trying to connect the dots. I am trying to connect the dots. And I'm trying to determine the role of the minister in this whole exercise. I can call anybody's name. I can defend myself.
Senator Mark.
Madam President, let me turn to you, please. So, Madam President, what we are saying is that the government has taken a decision to sell out the CLICO portfolio to their friends in Sagicor. That is what they have decided to do. And we want the government to tell this country today, how is the public interest going to be protected and defended if you have two bids? One, Madam President, is $300 million lower than the other. So Sagicor is bidding for the CLICO portfolio, but it's $300 million under Maritime Financial Group. And I would like to know, Madam President, whether the minister intends to get Sagicor to up its current offer to the same as that of
Senator
point
Mark.
of order.
Senator Mark.
Sorry.
Read your motion, the motion that you have filed, but you're also now imputing improper motives. I'm going to ask you to dial back in your remaining minute.
So, Madam President, this is a very serious matter, and we intend to carry to the campaign trail for the elections in September. Because we believe that the government is not sincere in its operation and its commitment to the people of this country. And we call on the government of Trinidad and Tobago to tell us this evening in this parliament what is the government's position on the sale of CLICO portfolio. Are they going to sell it to Sagicor? Are they going to sell it to Maritime Financial Group, or are they going to stop this whole transaction and restart it all over again to ensure that the people of this country get the best arrangement in the sale of this particular asset of our people? That is the question that I put to the government, and we will tell the people what you are doing outside here. I thank you very much, Madam.
Minister of Finance.
Thank you, Madam Speaker. Madam Speaker, in terms of the inaccuracies, untruths, falsehoods, fake news, I am sorry. It's too much, because I did not tell this Honorable House or the other place any of the things that Senator Mark has accused me of telling. None of the things that he says are in that article are in the article. It is absolutely ridiculous. And what is worse is what is the motion? I don't think at one point in time in that 10 minutes he addressed the matter on the motion for the adjournment, Madam President. The matter on the motion which I came to answer is the need for the government through the central bank to ensure that the interest of customers, policyholders, are protected in the ongoing discussions between CLICO and SAGICOR on the sale of the insurance portfolio of CLICO. That's what I came to answer, Madam President. Not that tirade that we got about ministers' parents and ministers' brothers who have absolutely no connection to this whatsoever, none whatsoever, and all of this foolishness about maritime. This is not an emotion. This is not any matter, Madam Speaker. So I will answer what I came to answer. Suffice it to say, every single thing the Senator said is false. Suffice it to say. At no point in time did I, as Minister of Finance, or any other member of the government indicate even an iota, a smidgen of a decision or policy to sell out the traditional portfolio of CLICO to SAGICOR. At no point in time have I, as Minister of Finance, said that or anything even remotely close to that. And that is why I say everything Senator Mark said was absolutely false. Let me put on the record what I said. I said that the central bank, which has taken control of colonial life under the relevant legislation, has made a proposal to me as Minister of Finance for my review and approval with respect to the sale of the traditional portfolio of colonial life. That is all that has happened. The central bank has made a proposal to me as Minister of Finance for my review and approval with respect to the sale of the traditional portfolio of colonial life. And I said that as Minister of Finance, I am not a rubber stamp. I have to be extremely careful. I have to protect the public interest, and I have to weigh up the pros and cons of that proposal that has been made to me by the central bank. This is not the government's proposal. It is not the government that's selling out anything. The portfolio will be disposed of, if it is disposed of, by the Central Bank of Trinidad and Tobago, not by the government, not by the government at all. And let me just deal with the matter I came to debate, because a lot has happened since 2008, 2009, when we had the CLICO crisis, Madam President. And what happened then is that CLICO, CL Financial, and British American failed because of the culture and the behavior that was endemic in the CLF group at the time. The attitude of the persons who controlled CLICO at the time towards matching assets with liability, and their very poor asset risk control, and the weaknesses at the time that applied to insurance companies. Madam Speaker, when we had the failure of CLICO, Madam President, sorry, when we had the failure of CLICO, the Insurance Act only required insurance companies to have paid up capital of $3 million. We have since come to this House and the other place, and we have debated a new Insurance Act and passed it. It will be proclaimed very shortly, where insurance companies now have to put up capital to the extent of 150%
of their liabilities. So let's say, for example, the CLICO portfolio is worth $500 million or $700 million. Let's pick a number. The company that controls those policies will have to have matching capital of $1 billion, Madam Speaker. So we've moved from a situation where an insurance company was only required to have paid up capital of $3 million now to 150% of the total extent of the liabilities to policyholders. The rigor and the robust nature of regulation has also been vastly improved over the last 10 years, Madam Speaker. And I am satisfied, based on everything the central bank has told me, that their primary interest is to ensure that something like the failure of Colonial Life never happens again. And they are exercising due diligence and extreme care with respect to their proposal to me as Minister of Finance with respect to the disposal of the traditional portfolio of Colonial Life. However, I have to be very careful, Madam Speaker. I have to protect the public interest. I have to make sure taxpayers get maximum value in terms of the disposal of the CLICO assets, because the taxpayers funded the bailout of Colonial Life and CL Financial. So we have to return to taxpayers the money that they have received. And I must say, this government has been very successful. Up to the middle of 2018, this government had recovered $14 billion in CLICO assets, something they couldn't do. They pussyfooted for 5 years, played around, danced around.
Better language than that, please.
I apologize, Madam Speaker. They played around for 5 years because they had friends inside of there. They played around for 5 years, and they did nothing to monetize the assets of CL Financial and Colonial Life. This government was able to recover out of that $14 billion, $8 billion in blue chip assets, which were put into the National Investment Fund, which is now yielding dividends to taxpayers of this country. So we have always exercised prudence. We are proactive. We are performers. The time for old talk done, Madam President. This Minister of Finance is going to be very careful, protect the public interest, and I am satisfied that the central bank is also being very, very careful in its recommendations to me. I thank you, Madam President.
Honourable Senators, may I just, before I put the question to adjourn, may I just congratulate Senator Thomas, who made his maiden contribution. Honourable Senators, the question is that this Senate do now adjourn to Tuesday, the 9th of April, 2019 at 10 a.m. Those in favour say aye. Those against say no. I think the ayes have it. This Senate now stands adjourned to Tuesday, the 9th of April, 2019 at 10 a.m.
Call the elections in September.